Hi, everyone. This is Brian Cansian with Foundation. I see there are still quite a few people trickling in, so just wanted to say hello and let you know we're going to give it a few more minutes to let some other people get logged in here. So we'll get going in just a few minutes. All right, just a few minutes after the hour, we're going to go ahead and get started. My name is Brian Cansian. I am the Business Development Manager here with Foundation Software. I just want to welcome everybody. We're very excited to have you with us. We've got a great turnout. Got an exciting webinar for you this morning. Just a quick housekeeping item here. If you can see on the screen here, I want to remind everybody of our upcoming user conference called Converge 2024 down in Nashville, Tennessee. So we're going to be hosting this event for users of all of our products under the Foundation umbrella of companies. So whether you're a user of Foundation or Payroll Construction, one of the products in our HQ suite of products, including Project HQ and Safety HQ, or a product of one of our additional companies, McCormick Estimating, Estimating Edge, or WorkMax, please join us. It's going to be a great event. We have a lot of sessions lined up for education and just overall business concepts as well. So we're very excited about the event and look forward to having a great turnout there as well. Wanted to introduce you guys now to our webinar for today. We're very excited to have the folks from Traliant here with us to give you guys a rundown on 2024 updates for harassment and workplace violence in the construction industry. I know it's a hot topic and there's a lot of requirements of you guys to be compliant in this area, and we're just very excited for the information that they are here to present today. Speaking to you guys here today, we have two individuals. We have Alyssa Rossi, who is the Vice President of Compliance Services, and we also have Bailey Whitsitt, who is Corporate Counsel there at Traliant. So without further ado, also, we are going to welcome questions at the end. If you guys look at your dashboard, there is a section where you can type questions in. I'll be checking those out throughout the course of the presentation. You're certainly welcome to type those questions in, but we are going to hold those until the end of the session where there will be time for Q&A. So without further ado, I'm going to hand it off to Alyssa and look forward to what she has to say today.
Okay, thanks so much, Brian. And we want to sort of thank Foundation Software for welcoming us today. So I'm Alyssa Rossi. I am the Vice President of Compliance Services at Traliant. Traliant is a company that does compliance services for businesses. Primarily, that's compliance training. We do a lot of harassment prevention training. We also do other types of training, like code of conduct training. We do customized training. what Bailey and I do at the company is we do legal compliance. One of the things that Traliant has that is sort of special within this industry is we have in-house lawyers. So we keep our training sort of up to date and consistent with training requirements, training recommendations. We do that for United States training and for training around the world. So getting into sort of what we're going to talk about today, I'm just going to first give you a little overview of sort of what Bailey and I are both going to cover. I'm basically going to cover discrimination and harassment issues. So I'm going to talk a lot about what the EEOC is sort of signaling as far as their enforcement priorities and some guidance they've given as to types of harassment that they're going to be focusing on and that we expect might reflect sort of where employees might be having issues. That's good for employers to keep in mind because it is a place to say, oh, okay, like maybe discrimination related to religion is sort of going to be a growing issue. We need to go out to our managers and sort of make sure they understand what's going on with this and what they need to do and what they shouldn't do. I will also talk a little bit about state and local law, particularly with new protected characteristics. And then Bailey is going to cover workplace violence prevention. That is going to be sort of the larger part of the presentation today. There's a new law in California, and Bailey will discuss that in detail. So, okay, so going into harassment and discrimination prevention. Oops, sorry. So the EEOC in the end of 2023 released what they called their strategic enforcement priorities document. So this is their enforcement priorities for 2024 through 2028. I think it's particularly relevant for this audience because the sort of the first thing the EEOC calls out in these enforcement priorities is protecting vulnerable workers and people from underserved communities from employment discrimination. What they talk about is groups of like communities of workers who might be either unaware of their employment-based rights related to discrimination and harassment, and thus might not be sort of raising concerns with their employers or with the EEOC. Among sort of the types of workers the EEOC said they're particularly going to be concentrating on, immigrant and migrant workers who are in the United States on temporary visas, people with arrest or conviction records, temporary workers, low-wage workers, and people with limited literacy or English proficiency. So I think one of the things to keep in mind, like I said before, this is sort of just like intelligence for employers to use. Oh, okay, the EEOC is going to be looking particularly at these communities. What does that mean that we should be doing in order to protect ourselves from potential liability? And so that's really the way to use this. Looking at the enforcement guidance from EEOC, I think it's fair to say it doesn't necessarily mean they're going to be bringing a bunch of cases about this. What it might mean is that they're doing sort of education initiatives. Maybe they're going to unions and sort of saying, we want to partner with you to work with your union members who have English as not their first language. And we want to sort of do a seminar about their employment-based rights with respect to discrimination and harassment. That might sort of later on lead to additional concerns being raised by those workers, lead to complaints being filed. Another thing that the EEOC called out as far as an enforcement priority is preventing and remedying systemic harassment. So systemic harassment would be something that is sort of not focused on a particular individual, but could be something like systemic harassment related to immigrant and migrant workers who are in the United States on temporary visas, right? A bunch of workers either across an industry or sort of within like a relatively large company who are sort of just sort of systemically being denied some of their employment rights related to discrimination and harassment, right? They're not being sort of trained, they're not being told about their rights, they are unlikely to file complaints. Another thing the EEOC called out is eliminating barriers in recruiting and hiring. In this arena, it's sort of interesting. EEOC earlier in 2023 released some guidance as to the use of AI in recruiting and hiring, right? So that would be AI where company gets, scads of resumes or scads of interest in a particular job, and they use an AI app in order to sort of winnow those resumes. The EEOC released some guidance about what employers need to check to make sure the AI is not sort of embedding biases in the choices it's making about sort of flagging, okay, these are your sort of promising resumes and these are the ones that you don't really need to look at. A last thing that they called out in their guidance, the EEOC, is discrimination related to sort of basically world events, right? It can be local events, it's things in the news, right? Things in the news that are then sort of carried into the workplace. In the last couple of years, the EEOC has pointed out, particularly in this sort of area, anti-Semitism and Islamophobia. We have also received from our clients, with respect to their own harassment prevention training, we have received requests that we add content related to anti-Semitism and Islamophobia. I think it's again a good thing for employers to be aware of, because to the extent that this is sort of something that has come to the, this huge federal agency's interest, it might signal that it's sort of out in the community. The EEOC is always talking to plaintiff and defense lawyers. They're always talking to state agencies. They're always sort of looking at their stats for what kind of charges they're getting. A complaint to the EEOC is called a charge. And so this might reflect something that they're seeing sort of out there in the workplace generally. And they have some pretty good ways to get a sense of that. So it's, again, something employers sort of should be aware of and should watch, because it could be a source of liability and you just want to be prepared for it. So separate from the enforcement priorities, in 2023, the EEOC also issued proposed enforcement guidance. So this is not yet adopted. They issued this draft enforcement guidance, and then they take comments on it. And then they will, edit the guidance and make changes to it in response to the comments, and ultimately it will be sort of issued formally and it will be adopted. It doesn't have the strength of law, but it is a really helpful thing because it sort of pulls together harassment and discrimination law. And it also, again, sort of reflects what's going on right now. So the thing that sort of stuck out to me about this enforcement guidance is it reflects that the EEOC, and I think that they are with sort of some states and some local enforcement agencies as to harassment and discrimination, they are sort of together, sort of moving a little bit away from focusing so fully and so sort of narrowly on sexual harassment in the workplace. We went through the Me Too sort of era, and a number of states and localities really strengthened their laws about sexual harassment, right? They started to require more training. If they hadn't required training before, they started requiring it. They put in place a requirement that employers have more robust policies around sexual harassment. I think what's happening now is they're sort of stepping back and saying, okay, like we focused on this for a while. We need to sort of think about other types of harassment because that's also going on. One of the things in the enforcement guidance is that the EEOC sort of very pointedly said there have been a number of high-profile cases related to race and sex harassment. And we want to remind everybody that we also enforce Title VII's provision as to disability discrimination, religious discrimination, and national origin discrimination. And that would also mean harassment on those bases. So I think, again, it's a thing sort of to keep in mind. And I want to point out particularly religious discrimination. I think there is sort of in the sort of employment law community, what employers are seeing is more concerns being raised about religious issues, people asking for religious accommodations, people making allegations that some policy or practice at the workplace is somehow impeding their exercise of their religious rights, or it is leading to them sort of being treated less well than other employees who maybe are not religious. So again, it's something to keep in mind of. One of the things along these lines that the guidance talks to is the conflict between religious accommodations and anti-harassment law. And the EEOC doesn't spell it out in the guidance, but it seems like what they're talking about here is harassment prevention related to gender identity and gender expression, and how that can sometimes be interpreted by employees who practice religion as something that is offensive to them, right? And so it's a matter of the employer being in the not very great position of sort of mediating what is a disagreement as to like two workers. For purposes of like what employers need to do, the guidance very appropriately says like, you know, regardless of whether a particular worker has an issue with the way that the laws have developed with respect to issues like gender identity and trans people, the laws are the way they are and people can't be harassed on those bases. And so employers need to keep that in mind. So the last thing I want to talk about with respect to the guidance is separate from sexual harassment, there's also sex-based harassment. Sexual harassment is harassment that has some kind of content that is of a sexual nature, right? It could be touching, it could be comments, whatever. It is something that relates to, you know, sexual matters. Sex-based harassment is different. Sex-based harassment is harassment on the basis of sex, right? So it could be, you know, just sort of harassment on the basis that someone is a woman. It could be harassment on the basis of pregnancy or childbirth, could be on the basis of sexual orientation or gender identity. The important part to remember is it doesn't necessarily have to have that sexual nature component to it. And that is something that is obviously broader in the workplace, and it importantly includes sexual orientation and gender identity. The last thing I want to talk about with respect to the proposed enforcement guidance is that the EEOC takes the position in the guidance that sex-based harassment includes harassment of an employee on the basis of their reproductive health decision-making. So this is something that following the Supreme Court's decision in Dobbs, which overturned Roe versus Wade, a number of states, California, New York, and I think Illinois, put in place laws that said reproductive health decision-making is now a protected characteristic. So that means that an employee's choices as to contraception, having a child, not having a child, lactation, anything related to sort of that group of issues, that harassment is illegal because it's harassment on the basis of sex. The EEOC in this proposed enforcement guidance, it's not new and it doesn't have the force of law, but they did sort of remind everybody, this is also within Title VII, right? So again, it's just something to be aware of. If I were an employer, I would say anything that relates to sex, or like I would tell my managers, anything that sort of has any kind of nexus with sex or gender, be aware that there is sort of, that you are in sort of the arena where harassment or discrimination could be sort of like an allegation or an issue that arises later. That I think is sort of an easy and conservative way to approach it for an employer. Okay, so the last thing I'm going to talk about is state and local discrimination updates. We're going to talk basically about two types of protected characteristics that were added to state, and well, I'm going to talk first about New York City, so first about local and then about state with the next characteristic. So at the end of 2023, New York City put in place a protected characteristic for height and weight. So this is for employment, and so it means you can't make employment decisions based on height or weight, hiring, promotion, etc. Importantly, the New York City law has some exemptions, which are sort of ordinary and customary exemptions that exist basically across discrimination law. Like if if a particular characteristic, right, like think of like firemen's tests for strength and sort of endurance, right? If a particular characteristic is related to being able to perform the job, then an employer can take it into account. So that applies here for height and weight as well. Also, if height and weight sort of is a factor that would sort of affect the employer's ability to run their business, then it can also be considered. There's only one state in the union that has this on a statewide basis, and that is Michigan. And then you'll see on the slide, there's a number of localities, Binghamton, Madison, Wisconsin, San Francisco, Santa Cruz, California, and Urbana, Illinois, that also have this protection. I actually was looking into the other day to see like whether there's claims being brought for height or weight discrimination, and there actually have not been a huge amount of claims, which is sort of interesting. So we'll see if other jurisdictions start to adopt this, and also if it's something that really does add up to claims and potential liabilities for employers. It's a little bit hard to tell at this point. So the next issue I'm going to talk about is Washington State. So Washington State, effective January 1st, 2024, has a new law in place that says employers can't make hiring decisions basically based on lawful use of cannabis, right? So off-duty use that is lawful, sort of under the law of the state or locality where the worker lives, can't be the basis for the employer to say, we're not going to hire you because you use cannabis, right? Additionally, there is limitations on the employer's ability to make employment decisions based on the presence of non-psychoactive cannabis metabolites in the person's system, right? So I'm going to talk about sort of the testing issues later, but if an employer did a blood test and then they say, okay, you have non-psychoactive cannabis metabolites in your system, they can't say, we're not going to hire you on that basis, or we're not going to promote you on that basis. With these types of laws, this is an example of a law that similar laws are in place in different places around the country. As jurisdictions are sort of making cannabis use legal, this is something that is more and more coming into discrimination and harassment law. Most of the laws sort of are careful to sort of carve out and say, listen, employers can still say that they have a drug-free workplace. You know, what we're really going at here is sort of an automatic bias against someone because they use cannabis legally and off duty, right? So employers can still test for marijuana. They can't do that as like an employment screening device. But particularly for this audience, if the person is applying for a job that is a safety sensitive position, which at least some construction related jobs would definitely be, then an employer can take cannabis use, whether on duty or off, into account when they're making an employment decision, because obviously impairment on the job would be something that would pose a risk of injury or death. One thing to keep in mind, if you are in Washington State and you are sort of a construction employer who might have safety sensitive positions, is the employer has the obligation to identify the positions in advance. So that's sort of like a pretty common thing in discrimination law. What you want people to say, here's our policy and we're going to apply it fairly. And so if you have safety sensitive positions, flag those positions in some way. You could even put it in a posting requirement, sort of saying this is a safety sensitive position. And that way, if there ever is an issue, you can say, listen, regulator, we identified this as safety sensitive and we were allowed to sort of take off-duty cannabis use into account under the laws of Washington State. So, all right, so now I think Eric is going to talk a little bit about health and safety software.
Yeah, absolutely. Thank you so much. I appreciate it. And just as a quick kind of aside here, just to make people aware for those that, haven't seen emails, things like that, Foundation Software now offers Safety HQ. So there's a lot that we can do here. So this is fully customizable forms, like, you know, the usuals, inspections, site audits, JHAs, JSAs, HS or AHAs, things like that. But as we're kind of going to talk about a little bit in this presentation, we can also customize these forms to accommodate and manage things like, you know, violent acts of violence and things like that. So any kind of form or collection item that we need to do to collect, you know, collect information, we can fully customize those forms. We can do so for you, and it's a really good opportunity. So the system is really cohesive. It collects all of these things into one place so you can track and manage them by project, job, date range, who's involved, all of those things as you go. And as I mentioned, if you are, and you know, I think Bailey will get into this later, you are required to record every workplace violence incident, date, time, things like that. We can customize those forms to build and match and help you correctly and appropriately stay in compliance and measure those items. So in addition, we have toolbox talks that we can assign, manage, and assign out to folks from there. We can track and manage certifications, which kind of aligns with this as well. We can administer trainings and lessons through the application as well, available on iPhone, Android, tablet, laptop, whatever. And then we can get into a whole bunch of other stuff along with automated corrective actions, document storage, equipment management, things along those lines too. So if you are interested, we certainly have some tools and opportunities for you to do so. And again, aligns really well with what we're talking about here today. So that's one of the reasons why we mentioned it. But I guess from that point, I will kick it back. I don't know if Bailey's up or if we're going back to Alyssa, but yeah, I'm interested in hearing more.
Okay, great. Thanks so much. So I'm just going to switch over to Bailey and then.
I got it.
Oh, you do. Great.
Can we see my presentation?
Yes.
Okay, perfect. All right, so
I think
like,
we're on your notes page, Bailey. If you had just started it, I think we're still on the display with your notes.
all right, let me see. Is that better?
Nope, but
Yeah, I think Bailey, you can just pull that. If you pull the horizontal, okay.
do you have two screens? Because this one is your notes, and then the other one would be the full screen if you're trying to get there.
Yeah. Is that working? I'm sorry, guys.
Nope, still the window with notes and everything.
If I click, is it on the presentation?
Yes, but it's on the presenter presentation, not the audience presentation. Don't know. I am not a PowerPoint expert.
All right. It shows full screen for me.
Oh, that's it.
How's
You're
that?
good.
Okay, perfect. Sorry about that.
Now you just got to
All
maximize
right.
it.
Perfect.
There you go.
All right, so as Alyssa said, I'm going to be talking a little bit about workplace violence prevention, specifically this new California law. So to kick us off on this topic, we've got a quick poll. So how many American workers would you think are the victims of workplace violence each year? So I'll give a couple seconds to answer this. All right, so the answer is 2 million. 2 million American workers are the victims of workplace violence each year. It's actually the third leading cause of fatal occupational injuries in the US, and it specifically affects the construction industry. It was actually among the top 5 occupational groups with the most workplace homicides. So it's a very relevant topic, and we'll get into kind of what to look out for and how to be compliant with this new California law. So it's not just California that you need to be looking out for workplace violence prevention issues. Under the OSHA General Duty Clause, which requires employers to provide a safe and healthy workplace for all workers, that kind of covers workplace violence issues. So OSHA can impose penalties and fines for employers who don't take those reasonable steps to prevent workplace violence hazards. And you can be in violation of this general duty clause if you fail to keep your workplace free of hazards, if you recognize a hazard and don't do anything about it, if that hazard was a cause or a likely cause of death or serious physical harm. So it's definitely something to be looking out for. And OSHA can review any workplace violence prevention programs that you have. And if you don't have a program, they can go ahead and interview anyone at your company that's been victim of workplace violence to verify whether you have a plan in place or whether you're correctly implementing your existing workplace violence prevention plan. So beyond just issues that you could have with OSHA, you could also face tort liability for failing to protect your employees against workplace violence. So the FBI has issued some guidance on this. Screening out potentially violent people before hiring is an obvious way to prevent workplace violence. So some kind of red flags to look for. Past conflicts with coworkers, especially if violence was involved. Past convictions for violent crimes, a history of drug or alcohol abuse. And then even if someone doesn't show any of these red flags, but there is a workplace violence incident, we're going to be looking at whether you responded immediately to those threats of violence or workplace violence red flags. And if you didn't, you could be liable for negligent retention. So that's also something to look out for just generally. All right, so let's get into this new California law. It was passed September 30th, 2023. So like I said, relatively new. And it's a quick turnaround time. The compliance deadline will be, so it goes into effect July 1st, 2024. So the deadline would be June 30th, 2024 to be compliant. So by that date, employers need to inspect your workplace to identify any workplace hazards, create and implement the required workplace violence prevention plan. And I'll get into each of these elements. You need to complete required annual training on certain elements of workplace violence and then on your plan specifically. And then you need to begin keeping the required violent incident log. So because it's such a quick turnaround and plans are required for each work site, we recommend starting developing your plan and figuring out training now. All right, so which employers, employees, and workplaces are covered? Basically, all employers in California are covered, except there's a small exemption for workplaces that are not open to the public that have less than 10 employees working from that location. Basically, all California employees are also covered unless they are essentially working remotely. So the law says working from a location of their choice, not under the employer's control. So it's a pretty broad law, and it covers just about all California employees and employers as long as they have physical work sites. All right, so we'll get into what workplace violence even is and how it's defined under this law. So it includes any act of violence or threat of violence that occurs in a place of employment. And That includes threat or use of physical force against an employee. So that would be anything that results in or is likely to result in injury, psychological trauma, stress, regardless of whether that employee actually sustains an injury. And then it also includes any incident involving a threat or use of a firearm or any other dangerous weapon. So the law categorizes workplace violence by four different types of perpetrators. So type 1 violence is committed by a person who has no legitimate business at the work site. So for example, that could be somebody that comes in to rob a gas station, let's say. They have no legitimate business at that gas station except to commit a crime. Type 2 violence would be directed at employees by customers, clients, patients, students, inmates, or visitors. Type 3 is committed by a present or former employee, supervisor, or manager. And type 4 violence is committed by someone in the workplace, by a person who doesn't work there, but has a personal relationship with an employee. So a lot of the time when that is seen, it's a domestic violence issue. And then workplace violence doesn't include lawful self-defense or defense of others. Okay, so the big thing, aside from training, that this new California law requires is that employers develop a workplace violence prevention plan. So this plan needs to be in writing, needs to be available and easily accessible to employees to be able to review, and it needs to lay out hazards specific to each work area and what corrective measures the employer is going to take to address each of those hazards. So that means because it's specific to work sites and to the hazards at each work site, you will need a separate plan for each work site. So some of the major items that you need to include are the names or titles of people responsible for the plan. So you need to assign a plan administrator, and that person will be responsible for basically asking or answering any questions that employees may have about the plan. They're going to be your company's expert on your workplace violence prevention plan. It needs to include procedures to obtain employee involvement in developing and implementing the plan. So that could be, for example, sending out an employee survey on workplace violence hazards or issues that have been noticed by your employees. That can be a way to involve employees in the development of the plan. Needs to include procedures to accept and respond to reports of workplace violence and prohibit retaliation against employees who do report. Procedures to assure that managers and employees comply, and a procedure for how employees can report workplace violence concerns. It also needs to include how any concerns will be investigated and addressed, and then procedures to respond to actual or potential workplace violence emergencies. So that's things like your exit plan, or where employees should shelter in place in case of emergency. It also needs to include procedures to identify, evaluate, and correct workplace violence hazards. So for example, that can include inspections. How are those going to occur? How often? Things like that. And then procedures to review and revise the plan as needed, which needs to be done at least annually. And then in addition, when any deficiency is identified or a new hazard is identified. And so if you're looking for additional guidance, Traliant has written a couple articles on this topic, and these are linked within the PowerPoint, so they'll be available to you after. But this California Workplace Violence Prevention Law, the path to compliance, kind of walks through what is required under your plan, how to address the plan in your training, things like that. Oh. All right, so the law also requires that you, and Eric, this is what Eric just touched on, requires that you maintain a violent incident log. So that includes, or requires you to record any information for each workplace violence incident that occurs. So it needs to include the date, time, location of the incident, the type of workplace violence involved. So one of those 4 types that we just went over, a detailed description of the incident, but you should omit personally identifying information. So no names, addresses, or emails of anyone involved. You also need to include in the log whether law enforcement or security was called, how they were responded, what actions you took to protect employees from continuing threats, and then classification of the circumstances that led to the workplace violence incident. So was it because they were working in a poorly lit area? Was it because they were at a work site where they keep cash on hand and they were the victim of a robbery? That kind of thing. All right, training requirements. So like I mentioned earlier, the law does require you to train on the plan, your workplace violence prevention plan. So the training needs to be completed annually. But prior to that, you need to train before this June 30th, 2024 deadline, or by this June 30th, 2024 deadline. So the training needs to include definitions and requirements of the California workplace violence law. So that would include those 4 types of violence that we went over. It needs to cover your workplace violence prevention plans. So that includes how employees can get a copy of the plan at no cost, how they can participate in the development of the plan. You need to train on the violent incident log, how employees can report to their employer or to law enforcement if a workplace violence incident occurs. And then you need to train on hazards specific to that employee's job and hazards specific to their work site. It also needs to include corrective measures that you've implemented to address any workplace hazards, how employees can seek assistance to prevent or respond to violence, strategies to avoid physical harm. So, for example, that can be the run, fight, hide method. Also, how to get copies of the violent incident log. And you need to give an opportunity for interactive questions and answers with someone knowledgeable about the plan. So that could be your plan administrator, for example. And then beyond just the requirement that you need to train annually, additional training will be required if a new hazard is identified or a workplace violence incident occurs or the plan is revised. All right, I want to leave time for questions, so I'll make this part brief, but the law also requires that you create and maintain workplace violence records for at least 5 years. So that includes violent incident logs, records of any investigations, records of your hazard assessment. And then you need to create and maintain training records for at least 1 year. All right, so this will be enforced by Cal OSHA, and although we don't know what specific fines they'll be handing out for noncompliance with this law, it could definitely include citations or penalties, which includes fines, and that could range from up to $5,000 to $150,000, kind of depending on how big your organization is, how severe the violation or the workplace violence incident was, and then violations that could lead to higher penalties would be repeated and apparent hazard to employees, failure to comply with an abatement order, and inducing anyone else to violate this California law. So this law, it creates a lot of challenges for the construction industry specifically. So one of those obvious ones is that the construction industry may have several rotating work sites at any given time, and you're required to develop a plan for each of those work sites. And then you're required to conduct training for each of those work sites on each of those plans. And like I mentioned, those sites can be frequently changing. Another requirement under the plan is that you need to coordinate with other employers. So in the construction context, that could mean site owners, general contractors, and subcontractors. So you'll need to decide with these employers kind of which employees are going to be involved in plan development, which employees you're responsible for training, who's going to fall under what plan, who maintains the log, that kind of thing. So that will require a decent amount of coordination with several other employers. So this is something that Traliant actually offers help with. We have a workplace violence prevention training specific to this new California law that meets the training requirements under that law. So it can be used for employees in California or other states. It's scenario based like all of our other trainings. So it's not just kind of like a PowerPoint type slide where your employees will just be reading through information. It's more interactive than that. And it's customizable. So because the law requires you to train specifically on your plan, the training incorporates your workplace violence prevention plan within the training and addresses hazards specific to your employee's workplace and your industry. All right, so we've got our contact information here for both Traliant and FoundationSoft. If you had any questions or if you're interested in our workplace violence prevention training, feel free to reach out.
Great. Bailey, thank you so much. Great presentation. Just a reminder to everybody online here, in case you missed it earlier on, don't forget about our upcoming user conference, Converge 2024, down in Nashville, Tennessee. We have a great event planned for everybody. And at this point, I'd like to open it up for Q&A. There are a couple questions already in the queue here. So I'll just kind of throw those out there to, you guys, whoever wants to take it is fine. One simple one, a couple questions that come in about seeing if there was going to be a printable copy of this slide deck for this webinar. Not sure how you might get that out if you're willing to do so. Also along the same lines, someone asked if the slideshow is going to be available after the presentation. As far as the webinar itself, every registrant will receive a link to watch a recorded version of the webinar. So in that capacity, you will have access to this PowerPoint presentation, but obviously in the webinar format, it is not printable. So Bailey or Alyssa, do you guys have any options to receive a copy of this presentation?
I mean, I'm happy to share it if anybody wants to reach out. Yeah, I'd be happy to share. Alyssa, any other ways that we could share this?
Yeah, generally, I mean, maybe Brian, we can get with you, because I think ordinarily what we do for webinars that we do is we send all the participants a link to the presentation, and then they also get the recording. So, yeah. Brian, did you want to go to questions now?
Yeah, that was one of the questions, was if there is a printable copy of this. And like I said, I mean, we always send out a link to the recording, so it's always able to be watched. It's just a matter of where the actual PowerPoint file would come from. So that is a question that needs to be addressed. We do not have it. It would be ideal if it could just be downloaded somewhere, as opposed to potentially getting 199 emails. But I don't have a good answer for that one at the moment. I did talk to our marketing team here, and that we're not going to be able to have a link to a file on the recording site. So let's pause on this one, and we'll come back to how we might be able to distribute that if possible. So a first question, a real question here. As far as harassing, what if the person doing the harassing is the one to whom you are supposed to be reporting the harassment? What do you do in that case?
Yeah, so yeah, this is something that actually is addressed both in like EEOC guidance, which is just guidance, and also in some state regulations. Some states have regulations that require employers to have anti-harassment policies, and some of those states specifically require that the policies include multiple reporting channels, right? You always want multiple reporting channels, like separate from this issue. I will talk about this issue, but generally you just want multiple reporting channels, because you want the employee to be able to sort of report in a way that feels comfortable to them. Employees assume that they are going to be retaliated against. I have never, I do workplace investigations, and then I used to litigate in the employment space. I've never met an employee who believes that they can report a concern about discrimination and harassment and not be retaliated against. So it is like a hurdle to get over for employees to report, so you want to have multiple channels. For purposes of this specific question, you definitely want to have in your policy, and if you are an employee, I'll talk about it sort of from both viewpoints. If you're an employer, you want to have in your policy a thing to say, often the supervisor is the first line of report. So you say, if you have a concern related to harassment, discrimination, or retaliation, raise that with your supervisor or with HR, right? So you say, if you don't want to talk to your supervisor for some reason, maybe your supervisor is involved, like this question sort of presents, or maybe you just don't want to raise it with your supervisor. Like you and your supervisor are not, you're not the greatest fit in the world, and you would rather talk to somebody else. Often employers will say your supervisor or HR. And then usually sort of, it's a good idea then to have like even a third and fourth reporting channel for the employer's perspective. Somewhere where you say, often an employer will say, like in a place where it's not a huge corporation, but in a place like a law firm or a private equity firm, often the employer will say, report to your manager, report to HR, or report to the managing partner of the firm. And what that sort of signals both to employees and to enforcement agencies, if there's ever an issue, is we take this super seriously, right? We told employees, shoot an email to the guy that runs the guy or woman who runs the place, and that's how you can get your concerns reported. From an employee perspective, if you have a concern related to harassment or discrimination, check your policy and sort of, if you can, report in a way that is consistent with that policy, but both for your own sort of interest and also for your employer's interest, seriously. Even if the policy says you have to report to your supervisor and they don't have an alternate reporting channel, and your supervisor is the person who's harassing you, just go around your supervisor. Shoot an email to HR. If you have like a single HR person, or if you don't even have like a full-fledged HR department and there's just, somebody who puts the payroll together, go and talk to somebody and report the issue. It protects you as the employee, and it also is a good thing for the employer. I know employers don't often look at complaints as a good thing, but they are actually a good thing, because what they do is they raise issues, and they raise it in a way that employers have time to either avoid liability completely or to take action that will reduce their liability. So that's all I have on the question.
Great, thank you. So the next question pertains to surveys. What type of questions would we ask on a survey?
Right, so Alyssa, you can chime in too if you have anything else to add, but that's really up to you. It's kind of what's going to work best for your organization as far as involving your employees. So I think probably the easiest type of question to ask is to have your employees identify any workplace violence hazards they're aware of, any concerns that they may have about workplace violence within the work site. And then you can take that into account when you're conducting your hazard assessment. So if several employees have identified a certain workplace hazard, obviously that's something you're going to want to address and figure out how you're going to correct it. Alyssa, any other ideas for what we could ask employees in a survey?
No, I mean, I think generally sort of the California law, one of the things, the weird, sort of, well, maybe not weird, but it sort of unusual is it that employees need to be involved in the development of the plan, right? A survey is one way sort of to do that. And I think ultimately, right, it's just to sort of get information about on the ground issues. One thing that particularly I think is a good thing, it might, I don't know how common it is, but an employee might know better than anybody else, particularly better than a manager or someone sort of higher up in the organization, about issues relating to domestic violence that might impact the work site. So that would be something I would like, maybe not explicitly ask in a survey, but it would be something I would be mindful of as an employer. An employee who has a friend at work and they know like this person has a really abusive partner and that person has a lot of weapons, that is like seriously a workplace safety issue. So that would be the type of thing that you can get from the employee that's going to be difficult to get in any other manner.
Excellent, great. Another question asks, is the workplace violence plan only for the state of California?
As of now, yeah, California is the only state that requires it, but it's not a bad idea to have. They're the only one that has a law in place that requires specific elements. But as I went over, OSHA has that general duty clause that could cover workplace violence. So it's not a bad idea to have a workplace violence policy or plan in place, regardless of where you are.
Great. How about in maintaining confidentiality with record keeping? How do we document without naming names?
That's a good question. I don't know if there's any guidance out on this yet. Alyssa, any ideas? I mean, you will need to record where the incident occurred, the date and time, the type of violence involved. So there are several details that will need to be recorded, but the law just states that no specific personal identifying information, so like addresses, emails, full names.
Yeah, I think it's interesting. I actually spoke to a client about the course and about this requirement the other day. I think thinking about it, and I've looked into a little about sort of workplace violence, sort of regulations and how they're set up or whatever. So under the law, employees are allowed to get copies of the violent incident logs, right? So what this is trying to do by taking out the personal information, it's to avoid, like, you know, exposing confidential information related to another employee, or something where it's just a report and it hasn't been confirmed yet, right? So that could be an issue, like, it's not really like technically a due process issue, but it could be an issue that an employer says, like, someone just made a complaint that this guy made a threat, but we don't know if it's true or not, like, right? So the point, I think we don't have explicit guidance from Cal OSHA, but I think the point of taking that personal information out of the violent incident logs is because those logs can then get sort of broader disclosure among people in the workplace. And I think that the reason that information is not so much needed in the violent incident logs is the violent incident log is like a tool for the employer to use. We kept a log for a year. We had 10 violent incidents, and they all related to this type of violence, right? A retail store, all of the violence related to customers. That's where our problem is, right? That, I think, is the main purpose of these violent incident logs. Obviously, if you're investigating a report, the investigation materials can have people's names, et cetera, because that's absolutely necessary. But importantly, employees don't have a right to get those investigation materials. So that, I think, is sort of why that personal information comes out of the logs.
Great. What are the California training requirements? Is that level of training criteria determined by OSHA?
So the training requirements are laid out in, and you'll be able to see this in the presentation afterwards, but it's California Labor Code section 6401.9. And so that's who's laying out these training requirements, but it will be enforced by OSHA. So those requirements include the definitions of that law that are included in that law. So that'll be the 4 types of workplace violence that we discussed. It also requires you to train on the plan itself. So your methods for involving employees in its development, where you maintain your violent incident log, how employees can report, that type of thing. But yeah, they are all laid out in our PowerPoint and then also within that law as well.
Great. Great, great. Any other questions? Not seeing, where is the line between vetting potentially violent employees and discrimination based on past experiences in terms of EEOC and the hiring process? Great question.
Yeah, that is a great question. Alyssa, we can kind of tag team this one, but as long as you're not, as you're following, your state and federal laws for background checks, because there are some limitations, which it sounds like some limitations on the use of information from background checks under the ADA and other discrimination laws. So you do want to keep that in mind. And then obviously you don't want to be making decisions on any protected characteristic. But if, let's say, this individual that you're vetting has a clear history of violence in their workplace, or I don't want to say drug and alcohol addiction can be protected under some state laws. So you'll need to keep an eye out for that one, even though that was a red flag that we identified. But as long as you are keeping in mind any state discrimination laws and not making decisions based on protected characteristics, I would say that's kind of the line. Alyssa, anything to add?
Yeah, no, I agree. And I think, right, so there's not generally a protection for sort of past conduct, right, for employment purposes. So if you do have, like, if you think of the types of records that would be available, right, a sort of a fight that a person gets into with their neighbor, like fist fight they get into with their neighbor, where there's no like police on call, there's no sort of official record of it or whatever, that's not stuff you're going to find out anyway. So anything that an employer is going to be able to find out about sort of incidents of violence in the person's past are going to be stuff that is reflected probably in law enforcement records. So that would be something, right, where I would think, like having not looked at this specifically, but I would think that would be sort of an extra measure of protection for the employer, right? Where you would say like, well, this person was actually arrested for this conduct, or they pled guilty and then they were sentenced for this violent conduct. That would be something that would be like an extra measure of protection. But like Bailey said, definitely avoid protected characteristics, but sort of past conduct in general is not protected.
Great. We have time for one more question. I got it up here. Also, for those of you still online, if you'll notice I shared my screen, there is a link that you can write down there. Take that. It is a link to registration for the compliance courses offered by Traliant. Clients of Foundation are being graciously offered a 25% discount on those course licenses. So if you want to take advantage of any of those training services, go ahead and copy down that link and you can go out to their website and check that out. All right, final question. Are there any other states considering the same type of laws as California?
Not that I know of, but I think we see typically California kind of sets the precedent and other states follow. So I don't know of anything as kind of strict as this California workplace violence law, but I would continue to look out for something similar coming from other states.
Yeah, and the only thing I'll note on that is in New York State, a bill has been submitted in the Senate to require a similar sort of workplace violence regime as in California for New York, but only for retail businesses, right? Which is the sort of the big threat from sort of customer violence. I don't know the likelihood that that will pass, but it was introduced in the New York State Senate last month.
Awesome. Well, everyone, I don't know about you all, but I thoroughly enjoyed this. Alyssa, Bailey, I want to thank you for taking the time to prepare and present today. I think this was really great content, hopefully beneficial to all of you guys here attending. Again, the link is displayed here for those of you who want to take advantage of some of the training opportunities at a discount, and a link to the recording will be sent out to all of you guys shortly. And that's all I've got for you. Anybody else?
Yeah, no, thank you everyone for coming. I hope it was helpful.
Awesome. Thanks again, and to all of you attendees, appreciate the great turnout and look forward to seeing you next time. Thanks, everyone.